For example, if some incident took place in 2012 and some incident took place in 2017, you can't write the incident which took place in 2017 before 2012. You have to go in a chronological manner so that the one who reads the plaint understands it thoroughly and can easily connect the dots. So that is very important. Sometimes I've seen the interns who also work with me, they create a confusion by putting up some dates which were late, which incidents which happened later on, and then they just get confused with the facts of the case. So in such cases, I actually advise the students to please be very particular about the facts. You first go through all the documents and you collate them in a manner so that you don't go in a haphazard way. So the facts are completely on you, whatever you have to write in a chronological manner. And then the next slide. Yeah. So these are the last but the most important paragraphs of the suit after the facts after the facts end. After your narration of the story is over, you come to the fact showing how this honorable court has the jurisdiction. Like first you have to study that how your cause of action is arising in that particular jurisdiction. For example, if the suit is for permanent injunction against the defendant from anything or from occupying a property which is based out of Mukherjee Nagar, like in Delhi. Okay. So in such a case, you will be the court which will have jurisdiction will be Karkarduma. Or let's say if the property is somewhere in central Delhi, then the court will have jurisdiction is Patiala House, Delhi, or Rouse Avenue in Delhi. Okay. So this is how you'll have to show the court that why the this court before which I filed the case has the jurisdiction to deal with my to entertain my claim. Okay. So this particular paragraph needs to be very clear because usually the defendant, the first defense the defendant takes is of jurisdiction part only. They usually object to the jurisdiction of the court on the basis of various provisions of the CPC. So you first read it and then decide which court is going to have the jurisdiction, and then accordingly write the same in the paragraph. Then next is the relief which the plaintiff claims. You have to write exactly what is the relief which you are seeking, which you are claiming from the court, and on the basis of the basis of facts narrated in the previous paragraphs. So yeah. So when the plaintiff has let's say the plaintiff has in a particular property, let's say he has two shares. And one share he lets go. He let it go. Okay. Let it go to the other party, and he relinquishes his rights over that particular share. And he only claims right over one part of the share, one part of the property. Then he needs to mention it in the suit itself that where the plaintiff is allowed a set off or relinquish the total. Okay, what is a set off? That set off is a Alright, fine. That set off is when the plaintiff is allowing his suit to go, not go against a particular part of his claim or a particular part of the property, and he is relinquishing his rights over that particular part. Because he needs to let the court know that he has three shares in the property, then why is he not filing the claim against all the shares, and why is he relinquishing his right over one of the shares? He might have his own reasons, but he needs to let the court know about the same. So the last paragraph needs to be a statement related to value of the subject matter of this for purpose of jurisdiction and or court fees. Value, as I said, in Delhi, it depends on state to state, because that completely is jurisdiction is a state affair. State decides as per the laws applicable, that what are the jurisdiction, what are the jurisdiction decided for the district courts and high court. So in Delhi, it is up to Crores. The case will go to the district court. For Crores, the case will go to the Delhi High Court. So when a plaintiff has filed a case wherein his claims are worth or up to 2 crores, you file a case within the district court. But you need to write in the last paragraph that what is the subject matter, what is the amount of the subject matter, or what is the relief which the prayer, the claims which you are making are worth how much. When you mention that amount, that's how you let the court know that this honorable has jurisdiction, and you also let the court know that you have filed a proper court fees in support of your suit. Okay. So the next is money suits. In money suit, plaintiff needs to state the size amount claim, as I have already told you, that you need to mention the exact amount which you are claiming. For example, if you claim 2 crore or 3 lakhs, you need to mention it that this is the amount which I am claiming. Next is new property. Claim must contain a description of the property enough to identify it. It cannot be a random description. It needs to be very clear, because the court needs to decide whether that has the jurisdiction over that individual property or not. Therefore, you need to provide the exact address of that property. If in case it's an agricultural land, then you need to provide SRA number, etc. boundary numbers, structure numbers, etc. So that it's easy for the court to identify the land, identify the neighborhood property, and decide whether it has the jurisdiction over that particular property or not. Representative character, when you are filing it on behalf on not directly on behalf of someone else, but you also have a right over the subject matter. Then you write it properly, and you let the court know that what steps you have taken to institute the suit. Okay, so the plaintiff basically needs to show that the defendant is interested in the subject matter and is liable to be called upon to answer the plaintiff's demand. In order to answer the demand, you need to prove your case first. You need to satisfy the court first that why I am demanding and why the defendant is not in a position to deny this demand, and why he needs to come with the court and answer my question and and this court is supposed to give me a relief. Why? That right when you establish by way of putting your facts and by way of putting the law, by way of putting the documents which you annex with your claim. For example, you are suing for breach of a contract. You have to show it from the contractual process as to what was the exact contract you have signed and what exactly transpired after the execution of the contract. Why you think the defendant is in breach of the contract? What was the defendant supposed to do or supposed to, for example, a condition which was a particular condition which was there in the contract or not been fulfilled by the defendant. So and all these, for example, one conversation emails wherein you tell the defendant to perform a contract, but he neglects or fails without any reasonable grounds for not doing so. Those emails you need to annex, and then your demands that if after all the email conversation you finally are approved by your client to use any legal notice, legal demand notice, and then the defendant still fails to adhere to the terms and conditions of the contract, then you need to annex that legal demand notice as well, and such other documents which are fair enough to your claim against the defendant. All those documents need to be annexed to the plaintiff. Okay. So the next will be if the suit is instituted on a period of limitation. Now, this is also a relevant paragraph which needs to be mentioned. If filed, so the time period for filing a suit is 3 years. Okay, if the cause of action arose 3 years back, and if you fail to file it within 3 years, then you have to give proper reasons to the court why you failed to file it within the limitation prescribed. And then the reasons have to be sufficient enough so the court allows you to go on with the complaint. Okay. So another is relief needs to be mentioned specifically, simply or alternative, general or other, not necessary, but can be mentioned is required. So when you seek particular relief from the court, for example, in a suit for eviction, if you seek the vacation of the property, or you seek some kind of recovery of the arrears of rent, the tenant has paid you rent for 6 months, and you need that have that money from him, then you need to be very specific about your prayers. You can't just mix up your prayers, and you need to specifically mention that this is the relief which I am seeking from the court, and this is the this is the relief which I am entitled under law to get, and then therefore I am seeking on the basis of the facts and laws stated above. So if relief sought in settled distinct claims or causes of action found on separate and distinct grounds need to be stated separately and distinctly. If you're seeking different kinds of the claims which you're making are all different, they all are separate, and they all are arising out of the same set of facts but different in nature, then you have to mention in paragraph wise what exactly are the reliefs which you are seeking from the court. So basically, it all depends on the facts and circumstances of case to case. For example, if you are seeking a suit for partition, so let's say it's a 200-acre property, and you are seeking that all portions must be partitioned from the other siblings of yours, then you have to write it in the prayer as to what is the exact relief you're claiming. You want the court to pass on for partition of how much of the how much area of the property are you seeking, and that will be given by the court on the basis of the documents which you annex the complaint. Okay. So I think this is all I can tell you today about drafting of civil recovery suit, and I will also be sharing a draft suit which I think will help you all to prepare your assignments of drafting. And if there is anything which any one of you needs to ask from today's session, you all are free to ask. Anmol, Pradeep, Aditi, Anushri, Mohammed, Hemant, Ananya, Ananya, Tarek, Himanshu. Have you all understood?
Yes.
Which year are you all in? The majority of you?
First year.
Oh. Okay. Okay. Nice. So you these are actually very interesting as well as challenging, because you guys have just started reading law. I think you guys must have read the Contract Act
Yes, ma'am.
as of now. I think CPC will come in your third or fourth year. But CPC is vast, You need to read it, and most of the people lose their interest in CPC because there are so many documents involved, so many positions involved, so many orders and rules involved. Because the difference between civil and criminal is basically that civil is completely based on documents. Like you have to prove a case on the basis of the documents which are involved. So there's a lot of examination of the documents in civil law. So how those examinations are conducted? What are the rules, for example, for leading evidence? What is the procedure of leading evidence? How do you lead evidence? How do you file a affidavit of evidence? And each and every document, whether it's a original document or it's a photocopy of the document. Now, in an original document, it will always gain more weight than the photocopy of the document. Okay, so that's all. The procedural nitty-gritties are all mentioned in CPC, especially the execution part. That's the most challenging part of the whole CPC. So I think the basic provisions will be covered under your college curriculum, but actual sense of CPC is understood only when you come to the practice, because CPC is see, it's applicable in almost all the areas which are not criminal, all the areas, whether it's NCLT, whether it's arbitration, whether it's civil suit, whether it's divorce, whether it's suit for eviction, special suits, anything you say, CPC will be covered. And if CPC or civil court is not having a jurisdiction, that particular, for example, the DRT, the SARFIC Act, securities, I don't remember the full form now. It's basically SARFAESI is an act which has been enacted for the banks or the financial institutions for execution of their rights against borrowers. So under SARFAESI, there's a specific provision which says civil court will not have jurisdiction. Only debt recovery tribunal will have jurisdiction. So in such cases, civil courts will not have the jurisdiction, and debt recovery has its own procedure of going. But still, if you see, debt recovery tribunal also applies CPC. So CPC is in a way, mother guide of all the civil procedure, of all the civil cases. So it's very important to for all of you to read CPC properly, read the judgments, read the cases which are there in your syllabus, and I think yeah. So that's all for today's session. And if there's anything else, you can let me know. By the way, Preksha, I forgot to wish you all a very happy National Constitution Day. It's a very important day today. You all must read the basic structure of the Constitution today, because we all are standing here, we all are having such kind of sessions. It's only because of the Constitution of India, which has given us all the rights. And every citizen must be aware about his or her rights granted under the Constitution of India. Okay, and I think, Preksha, there are some questions. Would you want me to address them? I could see them popping up. Yes, definitely. I'm looking for good interns, but only if you're very sincere and punctual. Please let me know, because I'm very strict about the timings of my office, and the kind of work which I'm going to give will be completely related to drafting and research. So if anyone is looking forward to have an internship in Delhi, my office is in Jangpura A, Delhi. You can apply by sending your resume to my email ID. I'll share it with, I think Preksha and Srianshu is already having my email ID. So you can all send me your resume, whoever wishes to apply. What else? That's a that's a very big, I mean, very elaborate topic. I think there's a huge difference between practice in Supreme Court and lower courts. See, basically, I think first you all clear your law, 5 years, 3 years, whatever you are doing. First, you clear it. Then, exam which you need to write for the advocate on record is basically you need to have a 5 years of practice, and 1 year with an advocate on record, which who has already been an advocate on records for more than 10 years. So you need to take a training of 1 year, and you need to obtain a certificate of training from that AOR. And for complete six after complete 6 years, you'll be able to fill the form for sitting in the exam of advocate on record. And it's basically a very challenging exam. So you need to have a very you have to have a good speed of writing, because it's a very lengthy test. 4 exams are there. It's a very lengthy procedure, so you'll have to, at least 3 months before the exam, you should start writing. As of now, I think you guys still have the habit of writing, but when you come to the profession, you completely depend on the gadgets and the computers, and you start typing. So that's when it becomes very difficult for you to write and finish off the exams. So yeah, so there are subjects like drafting and moral, yeah, legal ethics, and practice and procedure. uh, and yeah, so these are the some of the subjects which are covered under the exam. And yeah, practice and procedure and case laws. So there is a set of case laws which the Supreme Court of India prescribes for all the AORs which who sit for the exam. Those are the general cases related to the constitutional law, which are benchmark cases, basis of which the whole the Constitution of India, the articles of the Constitution of India are involved, and the basic rights, basic structures of the Constitution are involved. So those are the very important cases. And then legal ethics will have the basics of practice of an advocate in Supreme Court of India. And the practice and procedure will have the day to day practice, which take place in the courts in the Supreme Court of India. For example, filing procedure, writing procedure, drafting procedure, curing of defects, etc. Then your what else? Drafting, yeah. So drafting exam is also very important. Drafting in Supreme Court, usually what we file is a special leave petition. So they will in the exam they give you they give you at least two special leave petitions for drafting, and civil appeals and criminal appeals, affidavits, everything in support of the SLPs you need to learn. Obviously, you first have to come to that. After 6 years of practice, you will definitely already be knowing about the drafts, about the special leave petitions in Supreme Court. So yeah, so that's the way the exam goes. The only thing you need to understand is that in order to clear an advocate on record exam, you cannot just sit in other courts and sit outside Delhi and from some other state and try to give the exam, because it's very important for you to practice in Supreme Court at least for 2 years, if not for six. So 1 year you can daily go to Supreme Court, and the another year you take the certificate from the AOR. But if you don't do that, then it becomes very difficult for you to clear the exam, because the questions are completely related to the practice applicable in Supreme Court of India. So therefore you need to be there in Supreme Court of India in order to clear the exam. Also, there are guest lectures taken by the senior advocates and very, eminent legal luminaries before the exam. So, usually, they are the examiners only. They only set the papers. So, that's why they give you the lecture of 2 hours, wherein they cover all the questions and topics which they might give you in the exam. So, that's also very important for you to attend before sitting for the exam. And there is a practice material available in Supreme Court's library, which you can always have access to. There's an online material also, and there are materials, hard copies are available in the Supreme Court library. Okay, so before coming to that question, I think another question which we were having is the difference between Supreme Court practice and High Court practice. See, the main difference is that first I will always advise you all to please go and practice in district court. Don't go by the what do I say, by the kind of lavishness, or the way, I mean, senior advocates are. Don't go by that kind of a thinking that if you go to Supreme Court directly, then people are going to assume that you are a very good lawyer and you have reached the Supreme Court very fast. That's not the actual idea. You have to first start from the lower courts, and you need to first understand the procedure which is applicable in the lower courts. Why? Because when you, after practicing for 3-4 years in lower court, when you come to Supreme Court, then you start understanding what are the lacunae which were left behind in the procedural aspect at the stage of lower courts, which can be challenged before the higher courts. So I would say that in the highest court of India, it's actually easy to practice, but it's very difficult to practice in the lower courts. Why? Because everything originates from the lower courts. Like, if today I file a plaint which is not proper, or which has not been heard properly, or which has been heard and allowed by the judge, and the defendant challenges it before the Let's say there was some lacuna in my plaint, but the judge chose to ignore it, and the defendant challenged it before the higher court. Let's say defendant fails there, fails in the high court, and finally when the defendant goes to the Supreme Court, and there if he shows to the Supreme Court that, legally the district court judge was incorrect, and he allowed my plaint despite there being legal lacunae, then Supreme Court will have the power to set aside the district court's order, or set aside the high court's order. If high court neglects it and it goes to matter goes to Supreme Court, Supreme Court will have the power to set aside the order. The whole litigation will be thrown. Okay, so all the number of years which I wasted in filing my plaint, and then going to high court, defending my rights, again going to Supreme Court, will all be wasted. It's almost a 10 to 12 years affair. So that's the reason why you need to first understand the procedure which is applicable in district court, and then you come to the higher courts. You start with high court and then you come to Supreme Court. If you come directly to Supreme Court, it is going to be very difficult for you to understand the procedure, because you will feel as if like everything is getting challenged. I don't understand why, what is the law behind it, because in Supreme Court nobody is going to argue on the basis of CPC, CRPC, or anything. Just one or two points they will raise, and they will show to the court that this is where the particular judge of lower court did not was not right, and therefore my appeal needs to be admitted. And that's how the arguments are, just take place in 2 minutes. They are not elaborate. But in district court, arguments go on for so many hours and hours and hours, and you understand the exact provisions, the exact section, why you have filed it, why that particular section was not mentioned, why this particular section was not mentioned, or why this particular section has been mentioned. All these things you will understand only in the lower court. So I suggest you first go to the lower court, then you practice there for 3 4 years, then you come to high court, and you go but in a proper chronological manner, in a hierarchical manner. Then you come to high court, and then you come to Supreme Court. Never ever dream to come to Supreme Court directly. This is my personal advice to all of you. I also did this mistake when I started. I straight away after getting enrolled, I went to a Supreme Court lawyer, and I said, "Ma'am, I wish to join you." But then she actually showed me the correct way. She told me, "Paromita, you go to the lower court first. You understand the procedure. Then you come to me. I'll keep you without asking any questions." Because as on today, I know the one who only has studied the law as per the lecturer's point of view, which you study in the curriculum in the college. So basically, that's not the way courts actually function. Courts function differently, and that you will only understand when you uh, come to the practice, understand the procedure, learn the procedure, and then you execute it in your own manner, in your own way, learning from your senior. Yeah. See, no draft is a perfect draft. Whoever asked that question, he or she needs to know this. No draft is a perfect draft. See, one draft you prepare as per the provisions. You get good books in the market for drafting. I'll send my suggestions. I have a couple of books where you find the exact draft and exact provisions which are required. So you start drafting as per the provisions and as per the facts which are available with you. You make one draft. You read it again. You will definitely find some scope of changes in that draft. You read it again. You will again find some scope of changes in the draft. Now you make someone else read that draft, that the other person will again definitely come up with something else to be added in the draft. Therefore no draft is a perfect draft. However, you can try to cover at least the exact procedure and exact language which needs to be written in the draft from the book and from the law, from the bare acts. You need to at least be very particular about the facts and try to make it a very good draft. And secondly, drafting will improve only by practicing. It won't improve if you just think that you'll draft something in 2 3 months, 4 months. If you are just drafting a suit for recovery, and then you forget about drafting completely. After 1 year again you think, chalo main ab ye bhi draft kar leti hu. That's not how you learn. You learn only by practicing. Every week you need to at least draft two petitions. Original drafting, drafting of original petition is different. Drafting of appellate petitions are different. In original you have to give all the facts. In appellate you have to challenge the order of the original court, the lower court. So therefore the language differs. Okay. So the perfection or nearby perfection will only be achieved when you practice it again and again, so much so that you do not forget the exact ingredients of a draft. And next time whenever you start drafting, you have that in your mind only. You don't need to read from the books. You have it in your mind that no, I need to mention this particular provision and this particular language from the act in order to make it a admissible suit or an admissible complaint. Okay, so please practice. Practice will help you in enhancing your skills of drafting. See, now this is again a question very personal. I mean, it depends on your understanding of issues, your understanding of the law. But I would suggest that you need to first see where you see yourself 5 years down the line. If you are seeing yourself to be a corporate lawyer, then definitely you should try reading and understanding IPR or corporate laws, company laws. If you think that you are going to make a very good litigator, then you study all the other laws like Limitation Act, Contract Act, then your insolvency, bankruptcy, DR, SARFACI, then CPC to padna hi hai because CPC is applicable everywhere. But it depends on your interest completely. But yes, I will definitely I think would like to add here that in terms of money, I think if you're really looking for making good money in future, then you go for corporate laws. And if you think that in the initial phase, if it's okay for you to work with lesser funds and practice and have a grasp over the basic practice areas, then you go for litigation. But it's a bit more of a struggle in litigation, because in litigation you must have heard that people do not pay very easily, whereas corporate firms, because you are joining companies, they pay you good amount of packages. But in litigation, usually you join some individual advocate who is probably sharing his or her fees with you. So it's not actually a salary, it's actually the remuneration which he or she pays to you out of his own pocket. So that's why it's usually lesser. That I can say, being a litigator and being a founder of my own office, I understand this thing that you as juniors find it very difficult to survive in litigation because of lack of money. But you also need to understand that we all are taking the money out of our own pockets, and that's why we are not able to pay you that high packages. But yes, if you're looking for high packages, then you definitely go for corporate laws, because corporates and companies pay a very good amount. Soft laws, are they applicable? Applicable means what? Soft laws are all these commercial laws, the non criminal laws, like, yeah, your recovery of money, NCLT, insolvency, bankruptcy. These all are covered under soft litigation, wherein no jail or no criminal or criminal liabilities, and no murder, assault, or such kind of things are involved. These are all soft laws, soft commercial laws basically. So these are all basically they take place between companies when when they file some recovery proceedings against each other. For example, in insolvency, bankruptcy, you you first send a demand notice to the party, and if they fail to pay you, then you file an insolvency proceedings, and then CIRP takes place. the company basically goes to insolvency state, and then there's a particular yeah, meeting, the community which is set, the with the board members, and then they decide how to go about the company, whether the company will be a running entity or it will stop functioning. And if the company is going to pay out of its funds, then who should be the creditors, who should be given the priority. The For example, some bank should be given the priority, or some other entity needs to be given priority in terms of payments. So these are all soft laws only. They are applicable, of course. We all are practicing. I am practicing majorly in soft laws only. So yeah, and there's very less scope of examination and cross examination in such kind of cases, because usually they are all decided basis of documentary evidence. So all the documents need to be gathered, and then you need to show the relevance of those documents, and this is how the soft laws are executed. Yeah. So the next step, international law scope. See, in India, I feel where there is very less scope. If you wish to practice, you'll have to see whether you want to go abroad and do an LLM in international law, and you can always come back. And if you want to go for teaching, then you can always teach international law, because it's a very scholarly kind of a subject, and usually not applied in day-to-day practice of practice in the courts of India. But yes, if you are interested, then you can definitely go for higher education. You can get a degree in a master's degree in international law, and if you have plans to settle down in abroad, you can definitely be a part of UN or such kind of big international agencies. If you're really expert in the field, then yes, on international level it can help you. Insights on the judiciary. Well, if you are planning to give the exam of judiciary, then I will say that you start reading and start preparing from now on, because once you are out of the law school, and you get lured by the kind of jobs which your friends are doing, then you get engrossed towards the wrong direction. You feel like it's okay to work and study at the same time, but that's not the case. Judiciary needs a lot of dedication, and it needs a lot of focus. You cannot obviously there are some extra brilliant minds who have also cleared judiciary along with their jobs, but there are very few. That's also as a matter of fact. So you need to study very hard for judiciary, and if you have that intellect, or if you have that kind of a interest, then definitely you should start studying from now onwards. And you should also take classes from various institutes who are providing judiciary coachings. And as soon as possible you should sit for the first exam, because after, if you keep delaying it and you think I'll give the higher judiciary, let's not sit for the exam now, then that usually becomes difficult with time. So you better give the exam at a young age, so that there are more chances of you clearing it without shaking your focus anywhere else. And yes, a lot of dedication, a lot of study is required. At least 11 hours a day is required. It needs to be dedicated only to studies, which you can't do now, but at least 2 3 hours you definitely should give to the preparation, so that your goal is clear and you crack it in one go in the judiciary exam. Yes, yes, yes. That's not an issue. If you have done, if you have been in the corporate laws also, you have practiced as a corporate lawyer, you can always come back to litigation. But yes, you need to at least dedicate a full year to understand the exact procedure, and to understand how to address the courts. Obviously, it's different in corporate law, because in corporate law you don't have the dais, you don't have the bench in front of you, and you don't need to address your arguments to convince someone. But in litigation, it is a day-to-day practice of, the skills of convincing the judge, and the skills of articulation, the way you have to put your arguments. It's very different than the corporate laws. Corporate laws are plain simple, what has been written in the book and what has been written in the act, those pointers need to be taken care of. But in litigation, you need to be very sharp and very witty, and very quick in understanding what the judges are asking you, what the other side is going to point out. So yes, there's a huge difference between corporate practice and litigation, but you can always switch to litigation if you wish to. Like, that is completely dependent on you. First 1 year you give to corporate laws. If you feel that you're getting bored, you're not liking it, then you can always try your hands on litigation. And usually it takes 3-4 years for the students to decide what is their calling. Taxation is very useful, I would say, because taxation is a subject which is, is not very competitive, I would say. There are very few tax lawyers in the market, and tax is a very complicated subject, and not all of them are able to practice tax. So I would say that it's a very less competitive market. You can always enter into the area of taxation and excel in it, and have you can make your own place in tax law. There's a huge scope. Yeah. Okay. I think we were 18 and now we are 8. But I really appreciate the thoughtfulness and the enthusiasm shown by all these students, because when I was a student I could never think of doing something like this on a Sunday. Yeah. Yes, correctly, correct. Yeah. Okay, all the best to all of you. Bye.
Thank you, ma'am. Have a good day.
Have a good day. Bye.